Right, good morning everybody. Well done for making it here today on what is an absolutely filthy day. So last week we just got to the very start of public body liability, and I think we got to the slide, and number 3, you should actually read number 2. So your first question is the matter justiciable? Now, did I go into this last week? I'm pretty sure I didn't. I did cover it. I did cover what justiciability meant. What does justiciability mean? Does someone want to? Yeah, we've got heaps to get through, so I'd really appreciate. Yes, thank you. Yeah, and what will they look at in deciding that? Did I go into that? Yeah, okay, so they're looking at, is this some kind of discretionary issue that the public body has, or is this an operational matter? If it's discretionary, for instance, how the public body has decided to allocate their limited resources, they will not look into that. They will consider that to be non-justiciable in a private law claim. Okay, and if it's operational, they will look into it. So that is often a distinction you see, this difference between policy and operational. Or something involving a public body discretion, the court's going to be like, we're not going to get involved in that, versus putting that discretion into play. Like whatever they've decided to do, how they put that into play. So one example, which will come to us, this case Rigby, but basically what happened there is the police were using some kind of canister, some kind of flammable canister as part of a way of fighting crime. And they threw it into a shop without any firefighting equipment. And that was found to be justiciable because it caused property damage to the shop. But what they weren't challenging was the police decision to use this type of flammable canister at all. They weren't challenging that. If they'd been challenging that, that would have been non-justiciable. That was a matter for police discretion. What they were challenging was using those flammable canisters without firefighting equipment. Okay, that was operational. So hopefully that distinction is broadly clear. Right, so once you're looking at a claim involving a public body and you've established that it is justiciable, then you move on to the normal duty of care inquiry. So, internal inquiry, harm caused needs to be reasonably foreseeable, and it's also necessary to demonstrate a proximate relationship between the public body and the individual plaintiff. So, in terms of this internal inquiry, the kinds of claims we see against public bodies are... Did I cover this last week? No, okay. Firstly, there might be a positive act in which the public body has done something positive that's caused someone damage. That's pretty straightforward. You know, has the public body made the claimant worse off? It's all about whether, in the reasonable contemplation of that public body, carelessness on its part might be likely to cause damage to the plaintiff. And alternatively, it might involve a claim by a plaintiff against a public body for an omission or for the act of a third party. Okay, and those same rules that we've talked about in relation to omissions apply to public bodies. So, public bodies are not normally under a duty of care to protect individuals from danger public bodies haven't created, including the injury caused by a third party, in the absence of special circumstances. But the special circumstances that will lead to a duty of care include an assumption of responsibility by the public body to the individual, control over the third party, and a special proximate relationship with the plaintiff, or a position of responsibility. Now, in relation to control over the third party and a special proximate relationship, so the case we talked about in that regard was Dorset and Home Office. Most of the cases that involve a duty to act based on this particular special circumstance involve public bodies. Okay, so this idea of having control over a third party, generally that involves a public body having that position of control. They have control over the risk or the danger because of their statutory powers. And of course, a duty of care can be owed to take action to protect a claimant from danger or injury if the public body has created that danger. And that can include danger resulting from human agency. Now, once you've established the internal inquiries yes, this matter is justiciable. Yes, it was reasonably foreseeable that this harm would be caused. Yes, there's a proximate relationship, either because it was reasonably foreseeable and they caused harm by positive actions, or because they fit in with one of these special circumstances in relation to an omission or the act of a third party. You then look to the external inquiries. And the external inquiries are often quite particular to public bodies. So first, looking at statutory context. Okay, so public bodies are created by some kind of statutory framework. And the question is, well, would recognising a duty of care here being owed by the public body to the particular party claiming a negligence against that public body, would that be compatible with the statute that governs the public body? You know, sometimes questions might come up like, well, is there an immunity in the statute? Because if so, then there will not be a duty of care. And that's exactly what happened in the case of Strathboss and the Ministry of Agriculture and Fisheries. You know, and they'll say, well, would it be even aside from the existence of an immunity, is it a case where recognising a duty of care would cut across the statutory framework and be inconsistent with it? So an example of that we saw in our pure economic loss in the case Carter and Attorney General, where the statutory framework under which the survey certificate had been produced by the public body was all about seaworthiness and safety. That was the whole purpose set out in the statute. Carter came along and tried to use that certificate and claim on it for a pure economic loss claim. He relied on it as part of the value of the boat purchased, and the court rejected that and said there was no duty of care. They looked to the statute under which the public body was acting when they prepared the survey certificate, and that determined the narrow framework, the narrow basis on which that certificate could be relied on. Another issue that can come up: would imposition of liability make public bodies more cautious and defensive in carrying out their functions? This is sometimes referred to as the chilling effect. Okay, so if that does happen, it's not going to be beneficial to the public, and the very nature of public bodies is that they're there to serve the public. So if one individual's claim is going to change the whole way the public body operate because they're worried about additional liability coming, then the courts will say, you know what, we're not going to recognise a duty of care here for this policy reason. So linked to that, would it involve a reallocation of resources? Again, in a way that wouldn't benefit the public, because the public body is so concerned about liability that they're going to do things in a very narrow way. And they might look at, was the plaintiff vulnerable to harm? Would a duty of care be consistent with the legal system as a whole? So the first four cases we're going to look at involve claims against public bodies that don't involve a third-party wrongdoer. And we're going to see here both acts and omissions on the part of the public body. So the four cases are Capital and Counties and Hampshire County Council, which involves three distinct claims within it. It's one of those consolidated claims that gets to a stage of appeal where the courts say, all these issues seem to be relating to the same defendant. They all are connected. We're going to hear them all together. We're going to compare it back to Kent and Griffiths, which we've already discussed. Then we're going to move on to Robinson, which I'm assuming you discussed with Joe. Nods, yep. And Tyndall and Chief Constable of Thames Valley Police, which is a really interesting decision that came out from the UK Supreme Court at the end of last year. It's one I recommend you read. Okay, so let's start with capital and counties and Hampshire County Council. So each of these cases involved a fire and the attendance of the fire brigade. As we'll see, in one case the plaintiff was made worse off by the fire brigade, and in the other two the claim was that the fire brigade had failed to confer a benefit. So the first case, the Hampshire case, the defendant fire brigade attended a fire on the plaintiff's premises, and at the time the fire brigade arrived, the internal sprinkler system within the premises was operating, and it was doing what it could to keep the fire under control. Now, when the fire brigade arrived, the fire officer ordered that sprinkler system to be turned off. Now, this had the adverse effect on restraining the fire, and once the sprinkler system was turned off, the fire spread rapidly and it eventually destroyed the whole building. The second case, the London case, involved the second defendant was a special effects company, and they had set off an explosion in some property, and things had got out of hand, and a fire had started. Now, some members of the public called the fire brigade, who attended the location, and they put the fire out, and then they left. But what they didn't do before leaving was check neighbouring sites to see whether there were any indications of fire on these neighbouring properties. And the plaintiff's premises was a neighbouring property that had been showered with debris as a result of this explosion, and it was later severely damaged when a fire broke out. So their claim was essentially that the fire brigade had a duty to check the neighbouring premises before leaving the location of the fire once it had been called to the fire. The third claim is the West Yorkshire case. Now, in this case, the plaintiff's chapel had caught fire. The defendant fire brigade arrived to put it out, but were unable to do so because they could not find a fire hydrant. So they're all those things, you see in the footpath with FH on them, they're fire hydrants. Now, the reason they couldn't find them was that, actually they found 4, but none of those 4 worked, and the other 3 couldn't be found, or were found so late as to be of little use because there was inadequate signage around their location. So the chapel was destroyed. So in each of these cases, there's no issues of justiciability, okay? There's no question about, some kind of allocation of resources or, policy decisions around how the fire brigade are going to use their resources, whatever, to fight the fire, or decisions around that. They are all operational. They are on the scene, they are there, they are fighting the fire, but they are not doing so in an adequate manner. So the first question the court asked was, is there a common law duty on the part of a fire brigade to answer calls to fires or take reasonable care to do so? And the court said no. Okay, there's nothing in the statute that gives fire brigades their powers, which imposes a common law duty to answer the call to help. So if the fire brigade fail to turn up, or fail to turn up in time because they've carelessly misunderstood the message, or because they've got lost on their way, they're not liable. There is no general expectation that fires will be extinguished by the fire brigade. The court said there's no doubt of help that they will, but they might arrive too late. or not at all, and for the most part, people rely on insurance. The next question, and we're going to just hold that thought and we're going to compare it to Kent and Griffiths. The next question was, once the fire brigade have turned up to the fire and started fighting it, at that point, do they owe a duty of care to the owner of the property on fire or to anyone else to whose property the fire might spread? Okay, so in relation to the first, to the second question, they said, well, the peculiarity of fire brigades, similar to other rescue services like the ambulance or coastal rescue and protective services like the police, is that as a rule, they don't create the danger which causes injury to the plaintiff or which causes the plaintiff to suffer damage to their property. For the most part, fire brigades and similar emergency services act in the context of a danger that has already been created, whether by nature, whether by a third party, whether by the plaintiff themselves. So they said, so that's generally what happens, but if a rescue or protective service by itself does create the danger which causes the plaintiff's injury, there is no doubt that the plaintiff can recover. Okay, this is a very simple case of a public body being liable for positive actions which cause physical damage. Just like an individual, provided you satisfy it within the reasonable contemplation of the public body that might result, then there will be a duty of care. So they went on to say, well, this could be a new and different danger to the one that the fire brigade has turned up to help get under control. So an example of that would be a fire engine arriving at the scene of the fire and being driven really carelessly and damaging the plaintiff's car that's parked on the road. Okay, so that would be causing physical damage by a positive action. There would be a duty of care in the ordinary way. Equally, creating, the public bodies will be liable for positive actions where they exacerbate and increase the risk of an existing danger. So in this case, in the Hampshire case, the first case we talked about, there was already a fire, right? Then the fire brigade arrived and said, all the sprinkler system must be turned up. That exacerbated the fire. So by their positive action of turning off the sprinklers, they exacerbated the fire. At this point, the fire went rapidly out of control and spread across 2 additional blocks of the plaintiff's property, which were all damaged. So the court said this particular conduct of the fire brigade, turning up and turning off a sprinkler system, fell into the category of the fire service creating a danger which caused physical damage. This is a positive act which foreseeably caused the fire to get out of control. And direct infliction of foreseeable physical damage is an established category where a duty of care exists. And going back to that difference between act and omissions, we can see here that the fire service made things worse than if they hadn't turned up at all. Okay, so that's a positive act. That's a good way to assess whether you're dealing with a positive act or an omission. Positive acts, much easier to establish a duty of care than omissions, where you have to fall within a special circumstance. Okay, so moving on to the other 2 cases, the London case and the West Yorkshire case, these both involved omissions. So there's no liability for an omission unless the plaintiff can establish that the defendant falls within one of those special circumstances, which are assumption of responsibility, role responsibility, control, and particular proximity. So, in this case, the plaintiffs tried to argue that there had been an assumption of responsibility. When the fire service turned up, they argued they assumed responsibility to the owners of the property or the nearby properties to put the fire out. They had essentially taken on the task of putting the fire out and therefore had assumed responsibility to take reasonable care to do so. And the plaintiffs tried to draw analogies with a doctor and a patient, where the general position is that whenever a patient is accepted for treatment, even through the public health system involving a public body, the doctor must use reasonable care and skill to cure them of their ailment. But the court here distinguished fire brigades to situations involving doctors and patients. And this is really interesting when you look at the nature of the job the public body is doing and how difficult it will be to establish an assumption of responsibility to a private individual. What the court said is that there is, in fact, no undertaking or assumption of responsibility by a fire brigade to owners of a building on fire or to nearby properties. Rather, the fire brigade's duty is owed to the public at large to prevent the spread of fire. And there can be conflicts in fighting the spread of fire between the interests of various owners of premises. In the course of fighting a fire brigade might have to enter and damage A's premises to fight a fire that is started on B's premises. In the Great Fire of London, the court said the fire service demolished a number of houses that weren't even on fire to make a fire break, to stop the spread of fire. So the fire service duty is owed to the public at large and not to individual property owners. And there was also this uncertainty, they said, around, well, who would the duty to put the fire out be assumed to? Would it be the owner of the property that was on fire? Would it include their neighbour? Would it include the entire town that would be ravaged if the fire was not put out? So because of this, they said there is no assumption of responsibility to the owner of premises or nearby premises to take reasonable care to put a fire out. So if the fire service have created a new danger, as in the Hampshire case, established a case of a duty of care. The second two claims both involved a failure to put the fire out, whether because they couldn't find the fire hydrants weren't working, or they failed to check the neighbouring properties. There was no assumption of responsibility in those cases on which to base a duty of care. The duty is owed to the public at large. It is not owed to individual property owners. And the court commented that outside positively increasing the harm, which is what happened in the Hampshire case, the fire service should be treated similar to private party rescuers who are under no obligation to rescue others and do not assume an obligation to act carefully if they do make a rescue attempt. The only obligation is to not make matters worse. So that defeated the duty of care for those two claims. They also went through the policy elements that the lower courts had considered would go against a duty, and they were unconvinced by these. So we're just going to quickly go through some of them, which are not here. So one of them was, because it's useful to see what sort of policy elements the courts will consider in these claims against public bodies. Okay, so the first one was fears that recognition of a duty of care would lead to defensive firefighting. And the court said no, we are not going to reject the existence of a duty of care on that basis. We wouldn't, had we kind of established that we'd gotten over these internal inquiries, we would not reject a duty of care on that basis, but rather, and I think this is really important, these concerns around defensive firefighting could be alleviated by having a very high threshold of negligence and reminding judges to give considerable latitude to fire officers and obviously other emergency services who make difficult decisions in difficult circumstances. Okay, so it's in this element of breach of a duty of care that a lot of the policy concerns raised around recognising whether or not a public body should owe a duty of care at all can be managed. Okay, you say, well, okay, so if there is a duty of care, but you've got to be pretty bad to breach it because of the circumstances in which they are operating. Another argument that had been raised was that private litigation was unsuitable for discovering the failures of the fire service. And because of this, a duty of care should not be recognised. Now, the actual evidence in the case went entirely against this. There had already been internal public inquiries into the failures of these public bodies, the fire service. But it wasn't until the private litigation was brought that the failures of the service were actually uncovered. And this is another interesting point about public bodies, okay? So even when a duty of care is rejected, and the courts say we're not recognising a duty of care here, or we're not recognising liability to this private individual, that does not mean the public body gets off scot-free and can continue to operate in a hopeless way, okay? There is always scope and perhaps a better use of resources is to find out exactly what went wrong and to try and fix the problem internally. There are often internal sanctions that can be carried out. We'll see that in some other cases too. The court said, look, it's undesirable to have private law action. Sorry, the plaintiff tried to argue, the fire brigade tried to argue that it was undesirable to have private law actions against authorities who were operating for the collective public welfare, and the court said, well, the case law doesn't bear that out. There are plenty of claims in the case books against the NHS. They tried to argue that finding a duty would distract from the main function of firefighting, and the court rejected that too. They said that would actually be true for any claim against a public body, but itself is no reason to recognise any kind of immunity. And they were worried about floodgates. The floodgates would open and there would be thousands of claims. Again, that was rejected. They tried to argue that it would result in massive claims, essentially against the taxpayer who would bear these costs out of public funds. Again, the court said, well, that boils down to an immunity of suit being argued for all public bodies, and that's just not how things work. So they were some of the issues that were raised and rejected by the court in terms of policy concerns. So in the end, Hampshire owed the duty of care to avoid creating a foreseeable risk of physical damage by positive conduct, and they were liable for turning the sprinklers off and exacerbating a fire that was already there. But the other two claims failed because they involved an omission and there had been no assumption of responsibility by the fire brigade to the individual property owners, and partly that is because the nature of the job done by the fire brigade is to serve the public at large each time they go to fight a fire to stop that fire spreading. Control and proximity weren't relied on here. And actually what's interesting is that I think that what you can see in the UK, that they tend to use that control proximity exception primarily in cases where there is a third party wrongdoer who the public body is in control of. But New Zealand is more open to control and proximity being applied in broader circumstances. And we will cover that. Strathboss is an example. Okay, so we've got this case capital and counties, where they've rejected the assumption of responsibility by the fire brigade to individual property owners. I think it's useful just to compare this to Kent and Griffiths and the London Ambulance Service. So remember, this case involved the ambulance that didn't arrive on time, and the Mrs. Kent suffered brain damage as a result of the delay. Now, in this case, they considered counties. Okay, they considered the dicta that had come out of counties, and they noted the different nature of the ambulance service compared to the fire service or the police service. And they said, look, we do accept that the ambulance service, the police and fire services are all subject to a statutory framework. All can be summoned by 999 calls or 111 calls, depending on, which part of the world you live in. But they said the tasks that they can be called on to do when they are summoned can be very different. I think this is a really important point, looking at the task that they have been called on to do and how this affects whether or not the courts will find that there has been an assumption of responsibility. They said the police and fire service's primary obligation is to the public at large. Okay, so if the police are protecting a particular victim of crime, they're performing their more general role of maintaining public order and reducing crime. In the case of fire, the fire service are normally concerned not just to protect a particular property, but to prevent the fire spreading across other properties, across the community. And so with both the police and fire brigades, there is a concern to protect the public generally. Whenever they're called out, you're protecting everyone from the acts of a criminal, maintaining public order generally, stopping the spread of fire. But when an ambulance is called, the position is a bit different. Certainly in the case of Kent, when the ambulance was called, the only person who was going to be adversely affected by failures on the part of that ambulance was Mrs. Kent. Okay, it was for her alone that the ambulance had been called. The risk that she was facing, which was this major asthmatic attack, was not one that exposed other members of the public to the same risk. So because of this, they said the relevant public body comparator is not other emergency services. So the relevant comparator for the ambulance service in this context was not the police or the fire brigade, but it was instead doctors and nurses who work under the NHS. Okay, and it's conventional that they all owe a duty to individual patients. And the court thought that there was no reason why the ambulance service, at least in a case involving these facts, should be any different. But they noted that, this might not always be the case. So there might be a call for an ambulance to go to the scene of a major accident where there are a number of people who need to be transported to hospital, and there were only so many ambulances who could do the job, and they needed to work out who to take and when. That might be the sort of thing that, might be harder to find a duty of care, or there might be, that might be resolved by having a very high standard of breach, given the context in which the ambulance are operating. But in this case, they weren't attacking any allocation of resources. There was no question ambulance was not available. Only Mrs. Kent was going to suffer if the ambulance didn't turn up. There was an assumption of responsibility. Right. So the next case, one thing I would, the main point I want you to take out of that comparison is that when establishing an assumption of responsibility from a public body to an individual claimant, it's very important to look at the nature of the task the public body are doing and who it is benefiting. Right, next case involves Robinson, which you will be familiar with. So this is the case where the police are trying to arrest a criminal and they knock down a 76-year-old woman in the course of doing so. And she's injured in the scuffle. Some important factors from this. It was not a situation in which the drug dealer had to be arrested at that precise moment, regardless of the risk that a passerby might be injured. Okay, on the arresting officer's own evidence, if he'd noticed someone was in harm's way, he would have just delayed by a couple of minutes before making the arrest. And the key part of the Robinson case is that the complaint was not that the police officers failed to protect the frail Mrs. Robinson, but rather that they made things worse by their positive actions. They knocked her over. Okay, so this was a positive act causing physical damage. Police generally owe a duty of care in accordance with the ordinary principles of the law of negligence for positive actions causing physical damage. Okay, and the court confirmed that there was no general rule that the police would not be under such a duty of care when discharging their functions of preventing and investigating crime. They couldn't say, well, we were in the course of doing this, therefore we don't owe a duty of care. No, that did not fly. They still had a duty of care not to cause physical damage by their positive actions. Sorry, I'm just going to go through this quite quickly because I know you've covered it already. I actually think it's quite useful. So they talked about two other cases. Because they're talking about injury caused by a positive action rather than an omission, it was quite straightforward that the police owed the pedestrian a duty of care. And they looked to a couple of other cases where duties of care had been recognised in relation to positive acts causing physical damage on the part of the police. Okay, so one case was Knightley and Johns. That involved a police officer who attended the scene of a road accident, and then they carelessly created an unnecessary danger to the plaintiff when they rode against the traffic flow around a blind bend, and that caused a collision in which the plaintiff was injured. And it was held here that the police owed a duty of care to that plaintiff. So yes, they're attending the scene of an emergency, but they still owe a duty of care to other members of the public not to create havoc and drive against the traffic around blind bends. And in Rigby, the police officers were attending a siege at a gunsmith's shop where a psychopathic intruder had armed himself and was firing from the building. And here, this was the case I talked about before, the police carelessly caused damage to the premises when they tried to end the siege by firing a CS gas canister into the building without any firefighting equipment. Okay, so that's again another case involved in police operations. They still owe a duty to take reasonable care not to cause physical damage by positive actions. But at paragraph 75, and I think this is really important, the court emphasised the importance of not imposing unrealistically demanding standards of care on police officers who are acting in the course of their operational duties. Okay, so this is where breach comes in. And this is where courts are going to say, we'll recognise a duty of care, but it's going to be difficult. The standard of care which they need to meet is going to be such that it's going to be quite hard to establish breach. We're going to recognise that they're acting in stressful situations. There may be little or no time for considered thought. So they will be very careful about whether or not there is liability against a public body in a situation that is involving kind of an emergency, stressful decisions, etc. So if we just reflect back to Robinson, perhaps, while a duty of care would have always been owed to the frail woman nearby, it might not have been breached if there'd been more urgency around the arrest. If they'd had to act then, or they were going to miss their chance, it's unlikely that duty of care would have been breached. But because there was an urgency and they could have delayed by a minute or so, until the frail old lady was out of harm's way, there was a breach in those circumstances. And in Robinson, that case confirmed that if the conduct would be tortious if committed by a private person or body, it was generally equally tortious if committed by a public body. But that is subject to the possibility that the statute or common law may authorise the conduct in question and require a departure from those principles, and of course, also if there is some kind of specific urgency to the situation. And public bodies generally owe no duty of care towards individuals to confer a benefit upon them by protecting them from harm any more than would a private individual or body. That is the case notwithstanding that a public authority might have statutory powers or duties enabling it to prevent the harm in question. So the court in the UK is very clear that the same rules that apply to private parties apply to public bodies. Okay, there's no shortcut between the statutory power to act and a common law duty of care being owed. Let's just take a 2-minute break and then we'll move on to Tyndall. We're going to have shorter breaks just because I want to get through the material. So let's come back at 9:50. 3-minute break. Okay, let's push on. So, next case, Tyndall and Chief Constable of Thames Valley Police. I recommend you read this case. I think it's a really good, clear case to read. It goes through a number of key cases in the area of claims against public bodies. So, what the case involved, Mr. Kendall was driving his car on a stretch of road very early in the morning. I think it was 4 or 5 in the morning in the UK. And there was black ice on the road. and he skidded and his vehicle overturned some distance down the road. So where the black ice was, and he skidded, and about 184 metres down the road, he'd overturned. So he called 999 to advise them of this accident and that there was ice all over the road and he was injured. Now, while he was waiting for the emergency services to arrive, he tried to warn approaching vehicles to slow down by waving vigorously. Now, nobody stopped for him, but they did slow down a little bit. Police officers then arrived and they erected a police slow sign by the carriageway. Okay, so they erected the sign, then they cleared the accident debris, and then they left the scene, taking their police slow sign with them. Mr. Kendall had also left by that stage in an ambulance. So shortly afterwards, Mr. Tyndall was killed when his vehicle skidded and collided with another vehicle that had also lost control on the black ice. His widow then claimed a negligence against the police on two grounds. First, she argued that the police officers owed her husband a duty not to make matters worse, which they had breached by causing Mr. Kendall, who was the original victim of this black ice, to desist from warning other motorists of the existence of that black ice. Alternatively, she alleged that the police owed a duty of care to take action to protect motorists from the danger caused by the black ice on the basis that they had taken control of the accident scene. So, at paragraph 44, so the court held that paragraph 44, they said there is a fundamental distinction between making matters worse, where the finding of a duty of care is commonplace and straightforward, and on the other hand, failing to confer a benefit, where you need to kind of fit within one of those special circumstances, otherwise no duty of care is owed. They said an example of the former, two examples of the former actually, of making matters worse, where there is a duty of care held by the police. Robinson, where the police knocked over the frail lady, and Hampshire case in Capital and Counties, where the sprinklers were turned off. Now, they said, look, one of the difficulties in working out what kind of case you are dealing with, whether you're looking at making matters worse or failing to protect from harm, whether you're looking at an act or an omission, is how to identify the baseline relative to which the defendant has made things worse. And they confirmed that the relevant comparison is what would have happened if the defendant had done nothing at all. Okay, what would have happened if the defendant had never embarked on the activity that has given rise to the claim? And so we can see that in Robinson, if the police had done nothing at all, Mrs. Robinson wouldn't have fallen over. There wouldn't have been a scuffle. Same with the Hampshire case. If the fire service had done nothing at all, the sprinklers would have remained on and helped keep the fire under control. So the general rule is that a person owes a duty to take care not to expose others to unreasonable and reasonably foreseeable risks of physical harm created by that person's own conduct, but there is in general no duty of care owed to protect others from risks of physical harm which arise independently of the defendant's conduct. But there are exceptions to that. These exceptions are the assumption of responsibility, role/status responsibility, and control/proximity. Okay, these are these exceptions we talked about last week. So question one for the court was, did the police make matters worse? So this involved the express consideration and judicial dicta of a new principle, although it had been an academic commentary, okay? And there'd been these academics who'd looked across cases and they'd said, actually, we think this is a principle, that there's a pattern we can see here, and we think liability should exist. And the courts acknowledged that commentary. I think Sandy Steele is one of the academics who'd drawn this out, and they accepted it, okay? They said, look, One way of making matters worse is if A knows or ought to know that B is in need of help to avoid some harm, and A knows or ought to know that he has done something to put off or prevent someone else helping B, then A will owe B a duty to take reasonable steps to give B the help he or she needs. Okay, so that is known as the interference principle. It is a particular way of making things worse. So the argument that was made here was that Mr. Tyndall and all the other motorists driving along the relevant stretch of road afterwards were exposed to a greater risk of physical injury than they would have been had the police never attended the scene of Mr. Kendall's accident. Because it was only following the police arriving that Mr. Kendall stopped warning oncoming traffic to slow down. He stopped making his efforts, believing the police would do so. Now, in terms of this interference principle, the court recognised that there was no case expressly in support of it. There was no case that had expressly accepted it. But they thought the result of Kent and Griffiths could be explained by it, by telling the doctor that the ambulance was on its way that put off the husband driving Mrs. Kent to hospital. It's a particular way of making things worse. Okay, now obviously the case itself was explained on different grounds and there being an assumption of responsibility, but this is a later court reflecting back on it and saying, oh, actually we could also explain it on these grounds. So the court said, yes, this is a valid principle. Okay, the interference principle is a way of making things worse. It is a way of establishing a duty of care. But they did not accept that it applied in this case. Okay, they said it is not enough to show that the defendant has acted in a way which has the effect of putting off or preventing someone else from helping a claimant. It is necessary to show that it was reasonably foreseeable to the defendant that its conduct would have this effect. Okay, the defendant they need to know or ought to know that their conduct would have this effect before they will owe a duty of care on the basis of the interference principle. At para 60, they accepted that the attendance of the police did cause Mr. Kendall to desist from attempts he would have otherwise made to alert motorists to this black ice. And it wasn't fatal to the claimant's case that nothing was specifically said or done by a police officer to encourage Mr. Kendall to stop those attempts. That wasn't fatal to the claim. It was enough that the attendance of the police had that effect. But what was fatal to the claim, what was fatal to the establishment of a duty of care on the basis of the interference principle, was that the police were not aware that Mr. Kendall had been attempting to warn other motorists. Okay? It fell down because of what the police knew or ought to have known about Mr. Kendall's warning efforts. As far as the police were aware, Mr. Kendall was simply someone who had been injured. Okay? He was a victim, not a rescuer. Now, when he'd called 999, he said he'd tried to flag down a van and it had slowed, but it had failed to stop. But that information was actually entirely consistent with him seeking assistance for himself. The whole subject of the phone call to the emergency services was his injuries and safety. He said, I need an ambulance, I've got pain in my chest, I've got pain in my back, it's hard to stand, there's smoke coming from my car. Okay, he didn't say I'm trying to slow traffic down because of how dangerous it is. That was not part of the call. So the crucial question is not, did the police cause Mr. Kendall to leave the scene, but rather whether the police could reasonably have foreseen that their attendance would displace Mr. Kendall's attempts that he would have otherwise made to prevent road users suffering harm. But his intentions, Mr. Kendall's intentions, were completely private. Okay, he hadn't actually mentioned that this is the thought process that had been going through his head. And that was the fatal lacuna in Mr. Tyndall's claim. So that resolved the first part of the claim. Okay, the police did not make matters worse. While the interference principle is now accepted in the UK as a particular way of making things worse, it didn't apply in this case. The reason it didn't apply is because it requires reasonable foreseeability on the part of the police, which they did not have. That was not established in the claim. Moving on to the second assertion on which a duty of care was alleged. She said, look, the police then otherwise owed a duty of care to road users, including Mr. Tyndall, to protect them from harm. As we know, this rule requires a special circumstance. So, question 1, had the police assumed responsibility to Mr. Tyndall to protect him from a source of danger that had not been created by the police? Had they assumed responsibility to Mr. Tyndall to protect him from the black ice? And the answer was no. Of course, there was absolutely no interaction between the police officers who attended the scene of the accident and Mr. Tyndall, who was in a completely different location and came driving along after the accident scene had been cleared. Next special circumstance. Did the police have a special level of control over the source of danger? Control and proximity. Was there particular proximity to Mr. Tyndall? So the argument that was made here was that because the police officer took control of the accident scene, that was the basis for a duty of care. Okay, so the leading authority on this is Dorset. But actually the court here, the UK Supreme Court, noted that Dorset has sometimes been explained as a case where the defendants created the danger. Okay, this is a slightly frustrating thing that can happen in the common law, is that you get this very clear dicta and you use it for a certain purpose, but courts then look back at it and they say, but we could also explain it on this basis. Okay, they say, well, actually, yes, Kent involved an assumption of responsibility, but we could also explain it on the interference principle. Yes, Dorset involved control and proximity. That was the express grounds on which the judgment was made, and that's the express grounds on which it's been relied. But it could also be explained on the basis that they created the danger. They also looked at this decision of Carmarthenshire County Council and Lewis, another case involving control and proximity. Now, in that case, a 3-year-old boy escaped the defendant's nursery school and ran out onto the road. And the driver of a lorry swerved to avoid this 3-year-old boy and hit a telegraph post and was killed. And his widow successfully brought a claim in negligence against the county council, which could be explained on the basis that that county council was in a position of control over the child. The court looked at these two cases, Dorset and Carmarthenshire, both involving the special circumstance of control and proximity, and said that the commonality between both of these cases is that the defendant had assumed a parental or quasi-parental responsibility. And so the question for the court here was, did this idea of control extend to any situation where the defendant has control over a particular source of danger, whether it be a human being, as in Dorset and Carmarthenshire, or an artificial or natural hazard? Or was it actually limited to these quasi-parental roles? Now, the plaintiff here tried to argue that Goldman and Hargrave was an example of this principle, and that liability based on control over land explains the case. But the UK Supreme Court were not so sure, and they were reluctant to expand Goldman in this way. But they said, look, so they said they raised a question: how wide can control be in the UK? Does it have to be this quasi-parental control? Could it be wider? They said, look, we're not going to decide that here. Even if the principle could be expanded, it did not apply in this case. The reason being, the police only took control of the accident scene. The black ice, which was the cause of the danger, was 184 metres away. They never took control of the patch of ice which represented the source of danger. And in fact, the court said, look, one of the criticisms the police are facing is that they did nothing at all about the source of danger. They didn't even go to inspect it. So the court said, look, the power of control, the police had the power to go and inspect it and deal with it, but the power of control without actual exercise of control is not capable of giving rise to a duty of care. Next, third exception, so that's assumption of responsibility, no assumption of responsibility, no control. Could they fit within the third exception, status/role responsibility? And the court said, look, the status of police as emergency responders does not support a duty of care on its own. We've talked about status being things like Goldman, when you own land, or someone who is in charge of children, child carers. These exceptions can morph into each other. I know that's frustrating. It's nice to have clear black and white lines to differentiate between them. They do tend to morph. But what's particularly interesting, so the two interesting things about this case, I think it's really worth a read. One is this indication in the UK that the control and proximity exception might be limited to a quasi-parental sort of role or a prison authority prisoner sort of role. It's a bit uncertain, but New Zealand does take a broader approach. And the second key thing to take out of this case is that it is authority for the interference principle, okay, as being a particular way of making matters worse. Now, this decision came out at the end of last year. It hasn't been reflected in New Zealand dicta yet, although I expect it would be. There are judicial statements citing academic commentary around this interference principle. And it seems to flow from ordinary principles in any event. Okay, so that is Tyndall. So, what has all this told us? Assumption of responsibility to an individual may be more readily found for some kinds of public bodies compared to others. Look at the nature of the job they're doing, okay? That is Kent going to help one person, the only person who was at risk, as compared to a fire service who, when they go to put out a fire, are actually doing a service to the community as a whole because fires spread. One way of making things worse is by interfering with another person's efforts to help someone. Even if a duty of care is found, the courts will be careful about the standard of care required, given that public bodies, and particularly emergency services, are often acting in pressured and intense situations. So even if a duty of care is established, liability might fall down on breach. So now we are going to move on to other cases, 8 cases, involving public bodies and third-party wrongdoers. We'll see if we can get through them all. First 3 cases involve claims against the police. The first 2 are from the UK, the third is from Canada. The next case, Couch, is a New Zealand Supreme Court case involving the probation services. Next case, Strathboss, we've already talked about, New Zealand Court of Appeal case involving the Ministry of Fisheries. Then we have a couple of cases against UK cases involving social welfare/housing authorities, and then a New Zealand case involving a claim against social welfare. As we go through this, I want you to think about what are the different policy concerns that are raised that affect whether or not a duty of care is recognised, the different approaches we see to control and proximity between jurisdictions, and also what an assumption of responsibility requires in this context. Have you discussed Hill at all with Joe? Yes, you have. Okay, we will keep Hill quick. So the first three cases involve the police. And each case involves a third-party wrongdoer. Okay, there is a third party who has done the crime, and someone is saying to the police, you actually had a responsibility to stop that before it happened. And there's evidence in these cases that the police have done a really poor job. Okay, and they haven't taken care in doing what, in their, carrying out their statutory duty of suppressing crime. But as we know, notwithstanding the fact that the police have statutory duties and power and responsibilities to suppress crime, they're not liable for failing to commit criminal conduct by third parties or failing to safeguard people from danger unless they can fall within one of the exceptions to claims involving pure omissions. Okay, and the two exceptions that are generally considered are control and proximity and the assumption of responsibility. So Hill involved the police operations in finding the Yorkshire Ripper. The mother of the Yorkshire Ripper's last victim, Jacqueline Hill, sued the police for failing to protect and prevent her daughter's death. And, there was a lot of evidence that the police had performed pretty poorly here. They could and should have caught the Yorkshire Ripper, Peter Sutcliffe, before he murdered Jacqueline Hill. They were diverted by an evil hoax. The officer who interviewed Peter Sutcliffe hadn't been properly briefed. The report into Peter Sutcliffe hadn't been given proper attention. The communication between different police forces was poor. It had led to a delayed capture. They'd actually interviewed him 9 times in their 5-year hunt. And this was a strikeout application. And so for the purpose of a strikeout, the police accept the argument that the court accept the argument that the police have failed to take reasonable care. But that would be by the by unless the claimant could establish a common law duty was owed by the police directly to Jacqueline Hill. Okay, and so this is what the decision in the strikeout concerned. Did the police force, in the course of carrying out their functions of controlling and keeping down the incidents of crime, owe a duty of care to individual members of the public who may suffer injury to persons or property through the activities of criminals? And the action was struck out. Okay, so first they looked at, there were 2 reasons why the claim was struck out, each sufficient in their own right to strike out the action. First, internal questions of imposing a duty of care. Did this case fit within one of the exceptions to the omissions rule? No. The Yorkshire Ripper was not under police control. Okay, so that, and secondly, so in terms of the control and proximity, they looked at Home Office in Dorset and they distinguished this case. They distinguished it because the Yorkshire Ripper was never under the control of the police, in contrast to the case of Dorset and Home Office, where the Borstal boys were under the control of the Home Office. Okay, and second, there was no special distinctive risk to Miss Hill as compared to all the young women who lived in the neighbourhood. And they contrasted this with Home Office, where there was special and distinctive risk to the yacht owners for the reasons we discussed. And they said, look, Miss Hill was just one of a vast number of the female general public at risk from the murderer's activities. The court said all householders are potential victims of a habitual burglar, all females potential victims of a habitual rapist. You need a special ingredient or characteristic to give rise to that necessary proximity between the police and the victim. That existed in Home Office in Dorset, but it was absent here. And there was nothing like an assumption of responsibility either. Okay, so internal, does this fit within one of those exceptions to the emissions rule? No, it doesn't. Okay, so internal inquiry is not satisfied. And they said, look, while these internal inquiries are enough to dispose of the claim, there are policy reasons that go against a duty of care. One was this concern that the exercise of police functions would be carried on in a detrimentally defensive manner. And they recognised that, and I think this is a really interesting one, and we can compare it to Michael next. But they said, look, in a police investigation, there are often decisions that need to be made on matters of policy and discretion, which are not justiciable. Okay, so in the course of a police investigation, there will be some things that are operational and are justiciable, and some things that are more policy discretion-based and are not justiciable. If in cases like this, which are essentially criticising the entire investigation, if liability were imposed in a case like this, the claim itself would involve elaborate, well, perhaps a better way of saying it is if we don't strike it out at this stage, a claim will involve elaborate investigation of the facts of the investigation, exactly what happened, before you could even identify whether the claim was justiciable. Okay, this has been a 5-year investigation, and they're going to be unpacking all of this investigation, and they might get to the point where the claim's not justiciable anyway. And the court felt that that would be a huge amount of police time, trouble and expense would be put into that, resulting in a significant diversion of police manpower and attention from their most important function, which was the suppression of crime. There's a quote here from Lord Keith, where he says, some actions might involve simple, straightforward failures where a police officer trips and falls while pursuing a burglar. Others would enter deeply into the general nature of a police investigation. You know, there's this variety of decisions that are made. Which particular line of inquiry is most advantageously to be pursued? How should we best employ our available resources? Now, lots of these decisions a court will not call into question, but it would be necessary to investigate all of it to ascertain whether this was so. Okay, so there'd be this huge diversion of police manpower and attention from the most important function of the public body that benefits the public, which is the suppression of crime. And Lord Templeman felt that, look, if it is the efficiency of the police force that needs to be investigated, that is much the better way to do that is through a public inquiry, which can look at whether the training that each of the officers receive is satisfactory, whether the rates of pay are sufficient to attract recruits of the required calibre, whether they have the necessary equipment, whether they have the necessary facilities. A private tort action was not the appropriate place for it. Interestingly, the failures of the police force in this case, so there was no duty of care in Hill, but the failures of the police force were found to be significant separately. Okay, so separately the government did order a review of the investigation, which led to significant changes in the investigative procedures which were adopted across all UK police forces. So that's it. This difference between what is the problem here? Do we go down and spend all this, require the police to spend all this time and effort just to defend one private law claim brought by an individual? Or are we better off doing some kind of more broader investigation which can actually result in the improvement of procedures that will benefit the public? So that's one of these policy issues that come up. But we'll leave Hill there. It's a bit of a... It's a case we can just park there. Now, the next case is Michael and Chief Constable. Now, I'm sure you've discussed this already too. Yeah, okay, it's one of the significant UK cases. So, it's actually a devastating case, I think. So, Joanne Michael lived in Cardiff with her 2 children who were aged 7 years old and 10 months old. She called the police at 2:29 a.m. on her mobile phone and advised them that her aggressive ex-partner had come round to her house in the middle of the night, found her with another man, bitten her ear, was dropping home the man who he had found in her house, and had told her he was coming back to hit her. And then she said, he said he would come back to kill me. Now, the call had gone to the Gwent police station, and they graded it as requiring an immediate response. The call handler told Miss Michael, "You've come through to Gwent, I will pass it on to the police in Cardiff." Okay, so the call was passed on to the South Wales Police, but, and had it been appropriately actioned, because, she did say it required an immediate response, the police could have been at her house within 5 or 6 minutes. But devastatingly, when passing on the call handler failed to mention the threat to kill. And the South Wales Police downgraded the priority of the call so that it required a response within 60 minutes. 15 minutes later, Joanne Michael called again, screamed, the line went dead. Before the police arrived, she was murdered. Okay, so if the call handler hadn't erred, the police would have arrived at her home 6 minutes from the police station before the killer and been able to intervene and prevent her death. It is very clear the police have failed here. But that won't mean anything unless a duty of care to Miss Michael can be established. So, the question for the court is, did the police owe a duty of care to Ms. Michael on receiving her 999 call? So, unlike Hill, we can contrast Hill, where that claim was going to involve this huge kind of, let's unpick a 5-year-long investigation and work out what's gone wrong and where. This involved one very clear, simple, identifiable act of negligence involving a communication failure. Okay, so there are 2 phone calls that need to be identified here. The call from Miss Michael to the police, and then how that call was passed on. That's all that needed, that was all that was required. That was not going to take a whole lot of police time or distract from the job of suppressing crime. So some of those concerns that were raised in Hill that went against, those policy concerns that went against recognising a duty of care are not relevant here. Justiciability, this is purely operational. Okay, there wasn't a decision, there was clear this is how we grade calls, and there was a failure to grade in accordance with the manner in which calls should be graded. If someone calls and says someone's threatened to kill me, that requires an immediate response. So, duty of care, but what is being alleged here is an omission. Okay, the police have failed to protect her. So it's necessary to apply to try and put this claim inside one of these special circumstances before a public body or any other person will owe a duty of care for an omission. So the first exception, the first kind of special circumstance, is where the defendant is in a position of control over the immediate wrongdoer and should have foreseen the likelihood the immediate wrongdoer causing damage to someone in close proximity if they fail to take reasonable care in exercising their control. So this is the Dorset yacht exception. So this one here requires the analysis of 2 separate relationships, the relationship of the police with the wrongdoer and the relationship of the police with the victim. Okay? Here, because the murder of Miss Michael was never under the control of the police, the majority held that no liability under this exception could arise. The minority were willing to look into a proximity principle that could support a duty of care in limited circumstances, even when there was no actual control of the third party. And we'll come to what that proximity principle was. But the majority said no, you can't get into the control proximity exception. The reason for that being the immediate wrongdoer was never in the control of the police. The second exception the court considered was the assumption of responsibility. Okay, so this is where the law perceives that the defendant has done something to assume responsibility to the claimant to safeguard the claimant. Now, in one paragraph, the majority considered and rejected the assumption of responsibility. They said they were not satisfied on the grounds that the call handler merely said she would pass on the call. Okay, she gave no instructions or assurances that would satisfy the requirements of an assumption of responsibility. There was no promise as to how quickly the police would respond. She did say that the police would want to call her back and she should keep her phone free, but because she was calling on a mobile phone, that did not amount to advising Ms. Michael to stay in her house. And the call handler also asked her whether she could lock the house, but the court said, well, that didn't amount to an instruction that she should stay inside it. So the court here considered Kent and Griffiths, and they distinguished it. Okay, so both Kent and Griffiths and Michael involve an emergency call to an emergency service. Okay, whether or not the duty of care is established in each case is dependent on the content of that emergency call, what the emergency responders have said. In one, they've said, the ambulance is on its way, the ambulance is a couple of minutes away, they've continually provide misleading assurances that the ambulance is almost there when it isn't. And in the other case, they've just said, I will pass on the call, okay? In Kent, that was enough to establish a duty of care, and we also have the particular nature of the public body involved there. And that Michael, it was not, the content of the call was not enough to establish a duty of care on the basis of an assumption of responsibility, because all that was said was that the call would be passed on. So it didn't fall within either of these two exceptions which were considered. Now, just something just to think about here is that there is this concern that arises about call handlers becoming very cagey about what they say in an emergency situation to make sure they don't commit to anyone turning up. You know, like it's that concern that they have, like, oh, I don't want to say too much because what if something happens, etc. You know, and is that going to be in the public benefit if assumptions of responsibility rest on the content of an emergency call? Is that going to be in the public benefit? And is that going to lead to very unhelpful discussions with emergency responders? You know, I'm not sure that's the case. That's an interesting question just to reflect on. So in Michael, no duty of care was owed. It involved an omission. The case did not fall within either the assumption of responsibility or control over the third party. There was a possible avenue to recovery under the European Convention on Human Rights, and that issue was allowed to go to trial. But in reaching this decision, the court considered that earlier case of Hill and the idea that the public policies that had been identified in Hill went against recognition of a duty of care, and whether those public policy factors would support some kind of immunity against the police. And the court was very clear that there is no immunity for the police, okay, in carrying out investigations of crime, etc. That they don't have an immunity, but you still have to fit within one of those special circumstances that also applies to any private party before the police will owe a duty of care to confer a benefit on a private party. Now, I've put, this will be a horrible slide to read from where you are, but it's useful because there's some key dicta on here about claims against public bodies and the relationships that exist between public bodies and private citizens. And they talk about the different kinds of public bodies, okay? So in this first paragraph, in some areas, such as healthcare and education, public authorities provide services which involve relationships with individual members of the public, giving rise to recognised duties of care, no different from that which would be owed by any other entity providing the same service. Okay, so if you're getting your tonsils out, the surgeon owes you the same common law duty of care whether you're going through the public system or whether you're going through the private system. Okay, the surgeon can't say, sorry, but I'm doing this as part of the public body, so I don't owe you a duty of care. Okay, so that's when you've got the education and healthcare. These are established duties of care. Then they go on to say, look, besides the provision of such services which are not peculiarly governmental in their nature, health and education, it's a feature of our system of government that many areas of life are subject to forms of state-controlled licensing, regulation, inspection, intervention, assistance that are all aimed at protecting the general public from physical or economic harm caused by activities of other members of society or natural disasters. And it doesn't follow that just by setting up a protective system for all the public from public resources, that if it fails to achieve its purpose, the public at large should bear the additional burden of compensating a victim for harm caused. Okay, so that's this idea of when a public body is found liable, public funds pay the compensation. Okay, this is what can be sometimes referred to as a tort tax. The taxes we pay end up being used to pay a tort claim. That same amount of money needs to be used for everything. Is this the best use of public funds? That's a question that relates specifically to public bodies, that does not relate to private entities. And then they went on to say, the refusal of courts to impose a private law duty on the police, except in the cases where there has been a representation and reliance, does not involve giving special treatment to the police. It is consistent with the way the common law applies to other authorities vested with powers or duties for the protection of the public. The question is not whether the police have a special immunity, but whether an exception should be made to the ordinary application of common law principles, which would cover the facts of the present case. Okay, so the House of Lords is essentially clarifying that, or the UK Supreme Court, that the ordinary application of common law principles applies to the police. They're trying to put more emphasis here on the fact that the internal questions requiring a specific special circumstance before there will be a duty of care in relation to an omission were not satisfied here. Okay, so, you know, one way to think of it is if she'd called a friend and said, oh my goodness, so-and-so's come around, he's going to kill me, and that friend hadn't turned up to save her, would they owe a duty of care? No, neither did the police. They never said that they would turn up within a certain time, okay? All they said was that we will pass on your call. And then the question was, well, if the police had fitted within the internal inquiries, what were the external policy inquiries? Would they have prevented a duty being recognised in this? Very case dependent. If it doesn't involve a significant diversion of police resources, then arguable that those policy reasons that had been raised in Hill would not be nearly as strong. Now, what was also interesting in Michael was that an intervener from the Women's Refuge argued that even if the court found that the ordinary application of common law principles would not support a duty of care here, she argued that a duty should be recognised because the problem of domestic violence was so deep-rooted and so serious that there should be liability at common law for police failures to protect the potential victims. But the court rejected this, and they rejected it because they felt that that would just lead police forces to change their priorities and change the way they allocated their resources in a way that wouldn't benefit the public. Okay, and again, that is a type of policy concern that is only ever raised against a public body who has a duty to benefit the public. How their resources are allocated need to benefit the public. Right, now, just to briefly touch on the minority judgment here, this was, the minority judgment was issued by Baroness Hale and Lord Justice Kerr, and both of these law lords would have found that a duty of care was owed on something Lord Kerr called the proximity principle. Okay, so the majority have said no control and proximity, no assumption of responsibility. The minority said we would actually find a duty of care here based on the proximity principle. We think the proximity principle is a 4-part test. No, I don't have it. Which covers the following. This 4-part test applies if there is a close association between the claimant and the police, which could be created by information communicated to the police. So this was this phone call, close association. That info conveys serious harm will befall the victim if urgent action not taken. Okay, so these 2 elements are satisfied here. She's called the police, she said her ex-partner is going to kill her. That is serious harm. The defendant is a person or agency who might reasonably be expected to provide protection in these circumstances. Yeah, police are. You know, police can be distinguished perhaps from calling a friend who might not reasonably be expected to intervene because they would put them, they're not necessarily have the skills to do so. And that defendant is able to provide protection to the victim without unnecessary danger to themselves. Okay, so you can see this 4-part proximity principle, close association between the claimant and police. That info conveys serious harm will befall the claimant. The defendant is a person or agency who might reasonably be expected to provide protection, and they can do so without unnecessary danger to themselves. And they said it is very difficult to imagine what more would be required to create proximity of a relationship than a victim calling the police to tell them of a specific imminent attack on them. The police could reasonably be expected to provide assistance and protection in those circumstances without unnecessary danger to themselves. You know, it's relevant to this that the police system has been set up to deal with crime, and that stops us all taking crime into our own hands. Okay? Miss Michael couldn't protect herself with a pistol. She couldn't just have a pistol in her house to protect herself. That's what the police are for. Okay? So there's this general reliance on the police that they will do their job properly, and that stops us from taking control. We're prevented from doing it ourselves. And if you did go down this route of this proximity principle, then you avoid all these concerns about exactly what the call handler says to whether or not assumption of responsibility has been assumed or not, and having call handlers cage the content of their phone calls in an unhelpful way. But the majority, like I said, struck it out. So the clear position in the UK is that if a private party would not owe a duty of care in these circumstances, neither will a public body. Now, the last case I'm going to touch on is involving the police is Jane Doe and the Board of Commissioners of Police of Toronto. Now, they took quite a different approach to, we can contrast this with Michael. So this involved a serial rapist who was operating in Toronto, and Jane Doe was his 5th victim. The police had established a particular pattern to the first 4 victims. Okay, they were each attacked around the 24th or the 25th of the month. All the crimes took place in apartment residences in the Church and Wellesley area of Toronto. All the crimes took place against women who lived alone in 2nd and 3rd floor apartments with climbable balconies. And they were all single white women. Now, the police made a conscious, so there was this profile to the victims. Now, the police made a conscious decision not to warn any woman who fell within this category about the existence of the serial rapist, because they claimed they were worried that the woman would be hysterical and that would cause the rapist to flee and that would make it harder to capture him. Now, if you read the case, the treatment of the woman and the attitude of the police is absolutely appalling. But what we are interested in is the claim in negligence. So, essentially, the claim boiled down to negligence based on a failure to warn. Okay, because if the woman had been warned, the woman at risk had been warned, they could have taken steps to protect themselves. So they could have kept their windows locked. They could have shut their balcony doors and locked them, which they might otherwise leave open on the basis that they're not on the ground floor. The decision not to warn was made because the two sergeants assigned the investigation believed that women living in the area would become hysterical and they would panic and the whole investigation would be jeopardised. But various expert evidence and concessions made by the police led the judge to find that a warning could and should have been given. They could have canvassed the apartments, there could have been a media blitz, there could have been public meetings. Warnings would have alerted them to the risk and advised on precautions that they could have taken to protect themselves. So the question was, well, was there a duty of care to warn? Now, what is interesting is that this whole claim was approached via ands. Okay, so there wasn't we're dealing with an omission here. The police haven't created the danger. The police are not the immediate wrongdoer. What they have failed to do is protect the woman. But the Canadian court have approached it without consciously focusing on the fact it is an omission, and therefore the claim needs to fit within one of these exceptions. Okay, so they've approached it via ands. And they said, look, as between the police and Jane Doe, is there a sufficient relationship of proximity such that in reasonable contemplation of the police, carelessness on its part might be likely to cause damage to Jane Doe? Foreseeability. The police knew of the existence of the serial rapist, eminently foreseeable he would strike again. Proximity. They said the defendants knew or ought to have known the plaintiff had become part of a narrow and distinct group of potential victims, which was sufficient to support a special relationship of proximity. So the factors that led to this, the location of the attacks, they were confined to the specific area. Okay, the victims all resided in second and third floor apartments with balconies. Entry in each case was through a balcony door. The victims were all white, single and female. And it was concluded that these factors supported a duty of care. Now, the special relationship seems to have been based purely on the proximity of the claimant as being at special risk. They haven't focused on control over the wrongdoer. So for that reason, what I would say about this case is that, later cases have suggested it's on its facts. The reasoning is a bit loose. Oh, sorry, I've seen another typo. There is always that sister element of control when you're looking at an omission. So because of this, we might question the precedential value of it. We do see it mentioned in lots of cases. But so they accepted a duty of care existed, and they then turned their mind to breach. So what did the duty of care to protect these women require? Was the failure to warn a breach of the duty of care? Now, the court acknowledged that a decision made by the police not to warn might be reasonable. Okay, if it would cause general and unnecessary public, which could lead to greater harm, that could be a legitimate decision. But a legitimate decision not to warn would not excuse a failure to protect. The duty to protect remained and would need to be accomplished by other means. And here, they didn't warn and they didn't take any other steps to protect the limited class of victims. They were essentially treated as bait, and the police were held to be liable. But I think because the only focus of it was on it requires, the control proximity exception requires those two relationships, the relationship between the police and the wrongdoer, and the relationship between the police and the claimant. They only focused on the relationship between the police and the claimant. For that reason, we need to be careful how we treat this case. But it does show a vast difference between this and Michael, for example. So that is the end of our discussion relating to the police. The short point is, just like private individuals, they do not have a common law duty to protect individuals from harm caused by third parties unless they fit within one of the exceptions to pure omissions. Even if they do fit within one of the exceptions, we need to consider the policy reasons and whether or not they will prevent a duty being recognised. Now, if a duty of care to an individual isn't recognised, that doesn't mean that the police can be completely rubbish and get off scot-free. Okay, they can't just do a completely shambolic investigation or fail to pass on critical information and face no consequences. There are statutory responsibilities. There are always internal disciplinary consequences where appropriate, a public inquiry. Okay, there are public kind of law ways around this, but what we're looking at is whether a private individual can establish a duty of care. We have really ripped through this today. I'm sorry, I realise I only gave you one break, but we'll just carry on because we've got 8 minutes left. Does anyone have any questions? No? Have you kept up? Okay. We're now going to move on to a New Zealand case. Okay? This is Couch and Attorney General. It's a New Zealand Supreme Court case from 2008. So, have you discussed this case at all? Gosh, I feel like, am I repeating everything you've already discussed, or did you look at it from a different angle? Repeating or different angle? Oh, for ACC. Okay, I'm not talking about ACC. Right. William Bell, well, at least the same facts, it's good. It's good to have familiarity rather than having thousands of different cases. So William Bell had been convicted of aggravated robbery at a petrol station. He was eventually released on parole and allocated to a junior probation officer. She did not keep a number of appointments with Bell and failed to require him to report at all for significant periods. He was convicted for assault while on parole in a domestic context, and there was no change in his supervision or its adequacy. Now, it was a special condition of his parole that he should live at an address that had been approved by his probation officer. But he changed his address and she didn't check the adequacy of it. So despite knowing that he had been assessed as at particular risk of reoffending if using alcohol, despite knowing that the programs which might have addressed his dependency on alcohol had not been provided, she supported his decision to undertake a liquor licensing course with a view to obtaining employment which entailed the sale of liquor. So most critically, she allowed him to take up work experience at the Panmure RSA, notwithstanding known problems with alcohol, previous aggravated robbery convictions. Now, at the RSA, there were large quantities of alcohol available. There were also large quantities of cash. The RSA management were not told about his previous criminal record. Now, Bell worked at the RSA briefly and then he left, but he returned one morning to commit a violent robbery, and that ended in a violent assault on the claimant, Susan Couch, and the murder of 3 of her colleagues. Okay, so due to ACC, compensatory damages for Ms. Couch's injuries were barred. but she sought exemplary damages from the Crown for what she alleged was grossly deficient supervision of Bell by the Department of Corrections. And she alleged that the Crown were vicariously liable in tort. So this was a strikeout application, and the Supreme Court were unanimous that her claim was arguable and so should not be struck out. So it was arguable that the public body, the probationary service, did owe Ms. Couch a private law duty of care in supervising Bell's parole, which they had breached. But there was a difference of opinion on the legal principles to be applied. Okay, so we're going to start with the majority judgment, which was delivered by Justice Tipping. Now, it is very much an argument that focused on proximity and control rather than the broader policy issues which were specifically left to the substantive trial. Justiciability did not prevent any obvious obstacles. So in the judgment, Justice Tipping recognised that the law has traditionally been very cautious about imposing duties of care in cases involving omissions, in cases where a public authority was performing a role for the benefit of the community as a whole, and in cases where the actions of a third party, rather than the defendant, were the immediate cause of the loss. All three factors are present here. We have a public body, we have an omission, we have an immediate third-party wrongdoer. It was the third that is most significant here on the proximity issue, okay? So it was the voluntary and independent conduct of Mr. Bell that was the immediate cause of the harm suffered by Ms. Couch. And the causative link between what the Department of Corrections did and what she suffered was said to lie in the failure of the Department of Corrections to exercise either an available power of control over Bell or failure to warn of the risk he posed. So the question the court was considering was, does this case fit within one of the exceptions to the general rule that a person is not usually liable for the acts of a third party? So it's really important here to remember that this is a strikeout application, so it only needs to be arguable. They're not saying yes, they're not saying it has been established, they're saying it is arguable. Once all the facts were established at trial, it may not have been successful, okay? And in fact, the matter settled before trial. So in the strikeout application, there were two relationships that were important, okay? This case was argued on the exception, control, and proximity, okay? So the first relationship is the relationship between the Department of Corrections and Mr. Bell. For this relationship, they had to demonstrate that the Department of Corrections had sufficient power and ability to exercise the necessary control over Mr. Bell. Now, if you don't have the necessary control, the court felt it's inappropriate to impose a duty of care on defendants for the acts of a wrongdoer that they can't control. Okay, because you could never fulfill it. If you can't control it, you can't stop it. But as part of his parole conditions, he needed to undertake employment as directed by his probationary officer. And he couldn't engage in employment, which his probationary officer told him not to do. Okay, so the probationary officer knew about the problems with alcohol and knew he'd been accepted into this liquor licensing course and knew he'd been assigned to obtain work experience at the Panmure RSA clubroom. She had the power to prevent that employment at the RSA, and she didn't exercise it. Okay, she said, no, that's fine. Nor did she warn the employer and fellow employees about the history of aggravated robbery. So it was found that it was possible that Couch would be able to establish that the department, through the probationary officer, had the necessary power of control to establish that first relationship. The second relationship, and I'm sorry to stop midway through a case, but we are at 10:55. But what we will carry on with tomorrow morning is the second relationship between the probationary officer and Ms. Couch.
This is the microphone that doesn't work, and the one that does work has been taken, and all you're left with is that one.
All right.
Or the podium mic.
This one.
Podium mic is good.
Is it? Okay. I just need to
but
plug
it's
in my
gonna-
laptop.
Yep. Just here.
All right. Oh, sweet.
I'll go guest device.
Cool. Do you reckon I can get two screens?
Yeah, it'll come up on here in a sec. Yep.
Oh, sweet. All right. I'll go to this.
Hang on.